Let us talk about the Supreme Court first. The Supreme Court is the highest court of the country and the guardian of the Constitution. The Supreme Court consists of the Chief Justice, who is the highest judicial officer of the country, along with 29 other judges. The present Chief Justice of India is Justice N.V. Ramana. The seat of the Supreme Court is in Delhi. The Supreme Court is a court of record, which means it can punish any person who is in contempt of it. And the law declared by the Supreme Court is binding on all courts in India as laid down in Article 141. As far as the qualifications for judges are concerned, well, firstly, they should be a citizen of India, and secondly, a judge of any of the High Court for at least 5 years, or they should have practiced as an advocate in any of the High Courts for at least 10 years, or they should be a distinguished jurist in the opinion of the President. With regards to appointments, term of office and removal, the following points need to be remembered. Firstly, all the judges of Supreme Court are appointed by the President of India. Secondly, each judge shall hold office till the age of 65 years. Thirdly, a judge can resign from his office by giving a letter in writing to the President. Fourthly, Article 24, Clause 4 provides for the removal of judges. A judge can be removed from office on the ground of proved misbehavior or incapacity. And fifthly, he can be removed only by an order of the President passed after an address by each House of Parliament supported by a majority of total membership of the House and by a 2/3 majority of the members present and voting. Now, let's have a look at the powers and jurisdiction of the Supreme Court. Firstly, we'll talk about the original jurisdiction, which is laid down under Article 131. Here, it means that they have exclusive jurisdiction in any dispute between, firstly, the Government of India and one or more states. Secondly, the Government of India and any states on one side and any states on the other. And thirdly, two or more states. The second jurisdiction of the Supreme Court is the Appellate Jurisdiction. The Supreme Court has jurisdiction to entertain appeals from any judgment or order of any of the High Courts in all civil, criminal or other proceedings. However, as per Article 134A, the said High Court has to certify that the case involves a substantial question of law. Article 132 to Article 134 provide for the appellate jurisdiction of the Supreme Court with respect to any judgment, decree or final order of a High Court in both civil and criminal matters. Thirdly, we'll look at appeal by special leave. Supreme Court may in its discretion grant special leave to appeal from any judgment, decree, sentence or order passed by any court or tribunal in India under Article 136 of the Constitution. Fourthly, we'll look at advisory jurisdiction of the Supreme Court. Under Article 143, the President can refer to the Supreme Court either a question of law or a question of fact which is of public interest. This ensures a consultative role that the Supreme Court plays as well in the interpretation of laws or events. Fifthly, we have the revisory jurisdiction of the Supreme Court. The Supreme Court under Article 137 has the power to review any judgment or order made by it with a view to remove any mistake or error that might be in the judgment made earlier. Sixthly, we'll talk about writ jurisdiction. Now, under Article 32, every individual has a right to move the Supreme Court if any of their fundamental rights are infringed. The Supreme Court under Article 32 has the power to enforce fundamental rights by issuing directions, orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari.